You are listening to LawWithDenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your host is Denise, your experienced law teacher sharing knowledge on various areas of law, including contract, torts, the English legal system, and criminal law. Understand the law better and learn the skills you need to get the grades you need.
Hi, welcome to LawWithDenise.net. My name is Denise. In this episode, we're exploring the following. We're asking, what is acceptance? And we're also asking, what are the rules regarding acceptance and silence in English law? Now, acceptance is an unconditional agreement to the terms laid down by the offeror. So if we look at the case of Tinn and Hoffman, of 1873, we'll get a clearer understanding of what that means. In this case, Party A suggested a sale of 1,200 tons of iron, and Party B responded with a suggestion to purchase 800 tons of iron. This, the court said, was not an acceptance, because what Party B suggested was not an unconditional agreement to the precise terms laid down by Party A. So basically, if an acceptance is to be made technically in English law, what the offeree lays down on the table must look exactly like that laid down by Party A. You cannot modify the offer. Otherwise, it is not an acceptance. It's also important for you to know that acceptance can be made in several ways. So acceptance can be made by writing, as most of us know, but acceptance can also be made orally, and acceptance can also be made in conduct. If you think about unilateral contracts often look something like this. I will pay you £100 reward if you return my lost dog. Usually, acceptance to such offers are made by conduct. Additionally, imagine if you were to suggest that you want to purchase my bookshelf with all my books, and I decided I wasn't going to respond to you by email or by telephone, but all I did was deliver the bookshelf with all the books to your home or the proposed destination address suggested. This may well be viewed as acceptance by the court, and this would be acceptance by conduct. Now, if we think about acceptance by silence, we need to bring our minds back to the case of Felhouse and Bindley, because it is in Felhouse and Bindley that we get this legal principle that acceptance by silence is not recognized by the courts, or rather, silence is not acceptance in English law. And it is not acceptance unless it can be demonstrated that the offeree had an intention to accept. Now let's look at the facts of Felhouse and Bindley. In Felhouse and Bindley, we had an uncle and a nephew. The uncle wanted to purchase his nephew's horse. And the uncle said to the nephew, I will purchase your horse for £30 and 15 shillings. And if I don't hear anything from you, I'll take it that horse is mine. Now the nephew was selling various products, including he was selling various products at an auction, and he made it clear to the auctioneer that he did not want to sell his horse. But the auctioneer forgot, and the horse was sold to a third party, so not to his uncle. And this is where the problem arose. The problem arose because the third party thought they owned the horse, and the uncle thought he had an agreement with his nephew. And the question before the court was whether or not the nephew had actually accepted the uncle's offer. The court decided that, looking at the facts, the nephew had not made an acceptance. They said that silence is not acceptance unless it can be shown that there was an intention to accept. And after looking at the facts, according to the courts, the nephew had not demonstrated any intention to accept his uncle's offer. In 1995, we got an interesting decision from Selectmove, which also concerns silence and acceptance. And according to Selectmove, if it is the offeree who states that their silence will mean acceptance, then silence can be viewed as acceptance by the courts. So let us change the facts of Felhouse and Bindley to get a better understanding of what Selectmove really means in practice. So in Felhouse and Bindley, the offerer was the uncle and the offeree was the nephew. And it was the uncle, the offerer, who said, look, if I don't hear anything from you, the nephew, then I take it the horse is mine. And remember, the court said the fact that the nephew did not respond meant that there was no acceptance. But if we change the facts a little, we may see how Selectmove works. So let's change it so that it is the nephew who says, look, uncle, if you don't hear from me, then the horse is yours. So in our new scenario, the nephew is still the offeree, remember? But he's saying that his silence amounts to acceptance. And according to Selectmove, if we have such a scenario in which the offeree says that their silence amounts to acceptance, then silence may be viewed as acceptance by the court, or may or should be viewed as acceptance by the court. So there you have it. A quick definition of what acceptance is. Remember, it's simply an unconditional agreement to the precise terms of the offer. And then we looked at Felhouse and Bindley, which told us that silence does not amount to acceptance unless it can be demonstrated that the offeree had an intention to accept. Then we briefly looked at Selectmove, in which we were told that if it is the offeree who says that their silence will amount to acceptance, then silence may amount to acceptance in English law. So there you have it. I hope that was useful, and I'll see you soon. Bye-bye.
You've been listening to LawWithDenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your experienced law teacher sharing knowledge on various areas of law, including contract, tort, the English legal system, and criminal law. If you like the content, please remember to like, share, and comment. Thank you.